How do you analyze legal relevance on an evidence essay question? Remember, in our last video, we said step one on any evidence essay was going to be to establish whether each piece of evidence is logically relevant under the Federal Rule of Evidence, Rule 401. Remember, we said to do this, you're going to have to determine whether each piece of evidence was both probative and material. Probative meaning that the evidence had any tendency to make a fact more or less probable than that fact would be without the evidence, and material meaning that that fact was of consequence in determining the outcome of the action. So if we have both of those things, both elements are satisfied, it's probative and material, we called that piece of evidence logically relevant. And remember, it was important for us to note that the threshold here was very low. If something was only 1% probative and 1% material, we said that was enough to pass a logical relevance test under 401. Okay, well, 403, Federal Rule of Evidence 403, our legal relevance test, is a little bit different. Here is where we start to care about the actual amount of probative value a piece of evidence has. Whether it has 1% or 99%, we're actually going to care about that a lot more, because what we say under a 403 test is if the probative value of the evidence is substantially outweighed by the risk of unfair prejudice to the jury, then we're going to exclude that piece of evidence. That evidence fails our 403 test. So here, if something is only 1% probative and there's a high risk of unfair prejudice to the jury, it can be excluded under our legal relevance test. So just because something is logically relevant, again, and we discussed this in our last video, but remember, that doesn't mean it's automatically relevant or it's automatically admissible. It can still fail our legal relevance test. It can still fail under the Federal Rule of Evidence, Rule 403. So what happens on an evidence essay or in real life, it doesn't matter, when a piece of evidence is objected to under 403? In court, you might hear this, right? An attorney will interrupt a witness who's speaking on the stand and say, objection, Rule 403. Or you might hear something like objection, prejudicial, right? What that lawyer means when he's saying that is, I think that the probative value of whatever's being said right now is not high enough to warrant the risk of unfair prejudice. And the judge is going to have to then, in his head, make a determination. He's going to have to put that piece of evidence somewhere on this spectrum that I have drawn up here, right? And on this spectrum, what I have is probative value on the right side, and I have risk of unfair prejudice on the left side. I also have some other things. Federal Rule of Evidence 403, if you actually look at the statute, which I'll put below, you'll see that in that statute there's 6 things that are enumerated that have to be balanced with the probative value of the evidence. So most of the time when we're doing a Federal Rule of Evidence 403 analysis, legal relevance, we're focused primarily on the risk of unfair prejudice to the jury, but there are some other things that are enumerated in the statute that have to be considered. We have confusion of the issues, wasting time, undue delay, needless cumulative evidence. You can look at it below this video, and all of those things have to be considered. But most of the time when we're doing a 403 analysis, we're really focused on unfair prejudice to the jury. So that's what we're going to focus on in this video. But if the evidence is misleading the jury or confusing the issues to the jury, or it's wasting time, undue delay, or it's needlessly cumulative, someone's trying to introduce a 10,000 page document, right? That kind of thing could be so overwhelming. That could be needlessly cumulative. You would have to weigh it. What's the probative value of those 10,000 pages? What's the risk of wasting time, undue delay? All of those things, right? So, and again, more information about that will be below. But when we're talking about 403, we're usually talking about prejudice to the jury, or a risk of unfair prejudice to the jury. Okay, so back to my example though, right? So when someone raises a 403 objection, what that judge is going to have to do, and what you have to do on an evidence essay, is put that piece of evidence somewhere on this spectrum. And again, on the right side of this spectrum, we have probative value, right? What is the probative value of this evidence? The higher that probative value of the evidence is, the more to the right that piece of evidence will fall on the spectrum. And on the left, we have this risk of unfair prejudice. So what's going to happen is the more a piece of evidence becomes unfairly prejudicial, we move it to the left. And so what this really is a balancing test, right? That's what 403 is. So if we have a piece of evidence, we have to put it on this spectrum. And if it's anywhere from the midpoint to the right, we know that that is admissible, because the test is that the probative value of the evidence has to be substantially outweighed by a risk of unfair prejudice in order for it to fail a 403 test. Okay, so when you see this in real life in a courtroom and somebody objects and says objection 403 or objection prejudicial, this is what the judge is doing. He goes to his spectrum, puts that evidence down. He says, what's the probative value of this piece of evidence, and what's the unfair risk of prejudice to the jury? Okay, so let's do an example. Let's think about something, okay, and put it on this spectrum. Actually, you know, there's a really good example of this, a quick story, right? Because this illustrates everything you need to know about legal relevance. It's one of my favorite law school stories way back eons ago when I was in law school. Like many of you watching this probably are right now. Back in the day, I took a remedies class while I was in law school. And one of our first days, our professor separated the class into 2 classrooms. And he gave each classroom the exact same fact pattern handout, right? And it was a medical malpractice case, and he assigned each classroom the job of coming up with an award for damages. And the main question, I believe, was pain and suffering. So the plaintiff was seeking damages for medical malpractice, pain and suffering, right? Suing a doctor who he says has botched a surgery. So one group goes into one classroom, another group goes into the other classroom, and I think we were actually broken into multiple groups in each classroom. But the key here is we were given the exact same handout in both classrooms. So we deliberate for 30, 40 minutes, whatever. Each group comes up with a number that they think is fair in damages, and we all come back to present our findings to our professor. And so in my classroom, I was in we'll say classroom A and classroom B. I was in classroom A, and all of the groups in our classroom were coming up with a number between, 20,000 to 100,000, right? That was our level of variance. On the low end, groups were coming up with 20, 30,000. On the high end, groups were coming up with 100,000 in pain and suffering damages. Well, the groups in class B were all over $1 million in damages. And we're watching them present this across the room. And all of us are like, how in the world are they coming up with these multi-million dollars in damages? And it was every single group. And we had the exact same fact pattern. So of course, as this is going on, everyone's wondering what's going on. They're looking at us like we're crazy. We're looking at them like they're crazy. We all had the same fact pattern. What happened? Well, unbeknownst to us, the professor made one tiny change. In classroom B, the classroom that I was not in, he put photographs. He blew them up on huge posters, and he put photographs of the plaintiff's injuries. And they were very gruesome, very gory. I won't go into it, but I mean, it was, you can imagine, right? A very, very obviously serious medical malpractice case where this plaintiff had obviously suffered some pretty horrific injuries. And so he blew up these photos and he put them in the other classroom. And so the only difference was that the classroom B saw those photos and we didn't. And the difference in damages was millions and millions of dollars, even though our fact pattern was the exact same. Right? So what is happening here? Well, obviously, when you see these photos as a juror or as we did in that classroom, you are going to have emotion, right? It stirs up emotion. You can't help but look at those photos and not become angry, right? You're mad. How could another human being do this to someone else? You see the photos, it gets you riled up with anger, sadness, whatever, right? And that is what we kind of are talking about with this risk of unfair prejudice to the jury, right? Generally, we want juries to be as rational, to be as analytic as possible, right? We don't want a whole lot of emotion deciding cases, right? When juries are deliberating, we want them examining the evidence, the facts. We want them to try to remain as impartial as possible, right? That would be the goal. Now, obviously, jurors are humans, and we know that certain cases are going to be emotional by nature, right? And that's fine. But that's what 403 is grappling with. How much emotion is allowed and how much emotion is not. And the way we make this determination is by balancing, okay, what's the probative value of this evidence and what's the risk of unfair prejudice? So in this example, my professor's example that he gave us, right, we have, what is the evidence at issue here? We have photographs. We have photographs of the injuries. Well, photographs of an injury have probative value. In fact, they have very high probative value. If the plaintiff is suing the defendant for pain and suffering, the jury probably needs to see some evidence that there was pain and suffering, right? That is very probative and very material. A photo of injuries goes directly to the heart of the case, directly to damages. A photo is extremely probative. That has a very high tendency to prove the fact that the plaintiff suffered is much more probable when we have a photo. So it's very high in probative value and it's very material, right? That's an element of the case. Damages is going to have to be proven. And we're saying, look, here's photos of the damages. So it's extremely material. It's extremely probative. So on that scale, right, for the first photo of the injuries, we might say that that's over here, right? If we had to put the very first photo of the plaintiff's injury somewhere on this spectrum, we'd say, yeah, there's a risk of unfair prejudice here, but the probative value outweighs that, right? On our first photo, we would say probative value is too high, so that's legally relevant. But what starts to happen as more and more and more photos are getting introduced? Well, we would say that the next photo has less probative value, right? Once you've already established with a photo, you've shown the jury, hey, look, here's the fact that I suffered is more probable, right? You've already gone from 0% to very high, right? Before we had anything. So scratch that. If we don't tell the jury anything, except I suffered, right? But we don't have any photos or anything, that may or may not be believable, right? That's at some level, right? The jury could assign a level of probative value to testimony from the plaintiff saying I suffered. But you put a photo out there, that's going to make that fact way more probable, right? That's very visceral. They can see it. Okay, but the next photo, how much more probable does an additional photo make that fact of suffering? Well, it's going to be less, right? The material aspect of it stays the same, but the probative value definitely decreases with the second photo. And it's going to decrease more with the third, the fourth, the fifth, the sixth, right? And eventually, we're going to lose so much probative value with each additional photo that at some point, the risk of unfair prejudice is going to substantially outweigh the probative value of the next photograph. And at that point, we say it fails 403. That's no longer legally relevant, and the judge is going to exclude that piece of evidence. So what this all gets at, in a very technical way of explaining it, is sure, you can probably introduce 1, 2, maybe 3 photos, but if you try to come to court and put on a 50-page slideshow of gruesome, horrific photos, with the Saw theme playing in the background, right? At some point, it's gonna hit a level where, okay, this is just so prejudicial to the jury. The risk of unfair prejudicial is so high, and the probative value on the 50th photo starts to go down. At some point, you're just trying to anger the jury, right? We're out of the bounds of trying to show evidence of an element. You've already established that. We don't need 50 photos of the same injury, right, to establish that this injury happened, right? Which would be the test under logical relevance, make a fact more or less probable. So what this gets at is 403 is a balancing test. And the key here is to remember this spectrum. So if you're going to do a 403 analysis on an evidence essay, you could draw up this exact spectrum on your little piece of paper. And remember, you have to plot that evidence, okay? Somewhere on the spectrum. On the right side, we have probative value. On the left, we have unfair risk of prejudice to the jury. And you can even basically say, right, anything that's gonna fall in this box, you know, and this is completely arbitrary, right? But here's a little box. Anything in this zone, right, this is now going to be the substantially outweighing probative value, right? Because the probative value in comparison to this zone is substantially outweighed by an unfair risk of prejudice. So once a plot on your chart gets into this area, we can say, okay, well now we're saying that the probative value of that evidence is substantially outweighed by unfair risk of prejudice to the jury, right? And here we're looking for things that are going to stir up emotion, is going to be ancillary to the case, right? Anything that's just excessive, showing a bunch of pictures of something really gruesome, right? And just because something is gruesome in and of itself does not mean that it fails 403. That's fine. If something's gruesome, but it proves an element of the case, it's probative and material, well, the jury needs that. So it's okay to introduce emotional or gruesome evidence. That's fine. But when it hits a point where it's so excessive that we now say, okay, at some point the probative value is going to drop enough where the risk of unfair prejudice substantially outweighs that extra probative value we're trying to add with more and more photos. Okay? And it doesn't necessarily have to be photos or gruesome. It could be anything that's, you know, inflammatory to the jury, right? Somebody, and this is what we'll kind of start to get into in our next videos, but it could be a lot to deal with character traits. You know, someone's on trial for a violent crime and you're going to put on evidence that they lied on their resume 10 years ago, right? You know, that's the kind of stuff that could just be inflammatory. Or someone's on trial, or not on trial, but someone is in a breach of contract action and we're trying to say that they cheated on their wife, right? I mean, maybe that is some type of probative value, it shows whatever, like you could try to draw that up. The threshold level, remember, is very low. We could make that fact pattern work where it's probative and material, but do we really need to be bringing that in? What's the danger, what's the risk of unfair prejudice versus the reward of the probative value, right? And in that case, in a breach of contract action, unless there's some reason that that's really relevant or material, probably don't need to know that someone's cheating on their wife in a breach of contract action. That's just gonna inflame the jury. That's just gonna make the jury mad at this person and want to punish them, right? So that's kind of what we're getting at here on this balancing test. But I hope overall the key here to remember is step one, determine if it's logically relevant. Each piece of evidence, is it probative and material? Even if it's 1% probative and 1% material, that's enough for a logical relevance test. Step two under 403 is legal relevance. And if something has a very tiny probative value under your logical relevance test, that should be a red flag. If there's risk of unfair prejudice and there's little probative value, it's probably going to fail a 403 test under legal relevance. Again, the rule there is going to be what you're looking for, that the probative value of the evidence is substantially outweighed by the unfair risk of prejudice, which could be this zone on the spectrum, right? Okay, but with that, guys, I hope all of this makes sense. This is how it's gonna break down. In our next videos, we can move on to more issues in relevance. Maybe we'll go into character evidence. I'll have to take a look at it. But with that, guys, I wish you all the absolute best. I hope this video was helpful, and I'll see you at our next video.